Welcome everyone to the Federal Bar Association Key sections, the rounds FCA news with Tejinder Singh. The rounds is Tejinder's regular analysis of noteworthy FCA decisions. I'm Scott Oswald. I am chair of the Key section with Tejinder Singh, who is a partner at Goldstein Russell. Tejinder, hello.
Hey, Scott. Good to be with you.
Hey, we're talking about three cases today, all courts of appeals cases. The first one is UnitedHealthcare Insurance Company versus Becerra. The DC Circuit panel gives a tutorial on the differences between Medicare Part A and B fee-for-service cases and programs and Medicare Advantage capitalization programs. This isn't a False Claims Act case. Why is it relevant to all of our viewers?
So this case concerns the validity of what's called the overpayments rule, which is a rule that the Centers for Medicare and Medicaid Services adopted after the Affordable Care Act. And it basically says that if a Medicare Advantage insurer, that is a private company that gets lump sum payments from the government and is supposed to provide insurance to the government's beneficiaries, if that insurer learns that it's been submitting diagnoses that are not supported by the medical records, it's got to give the money back within 60 days, or it's going to be subject to False Claims Act liability. This action was brought by United Health Group challenging the validity of the rule. And it's a big deal because there are currently pending cases against a few Medicare Advantage insurers, including United Health, that say they haven't been returning overpayments. They've been knowingly submitting diagnoses that aren't supported by the medical records. And so they've challenged the underlying law here. And in this decision, the DC Circuit upholds it.
So the panel says that Medicare Advantage insurers have a financial incentive to code intensely. What does that mean?
So the way Medicare Advantage works is slightly different from normal Medicare. With normal Medicare, the government basically acts as your insurer. You go to the hospital or your doctor, you have a procedure done, and then they'll submit a bill for that procedure to the government. Medicare Advantage works differently because the government pays lump sums to the insurers, and those are based on the risk characteristics of the population. And the way that they kind of make sure they're getting the risk right is they don't actually report the procedures that are performed to the government. Instead, they report diagnoses. So patients that have more diagnoses or more severe diagnoses are going to be classified as riskier, and the insurer is going to get more money from the government as a result. And so the way that works out is that insurers just have an incentive to submit diagnosis codes as many and as grave as they can. And even if those diagnoses are accurate, they want to code them in a way that's going to get them the most reimbursement per patient.
So there's an interesting quote from the panel. An unsupported code submitted by a Medicare Advantage insurer triggers overpayment in every case. That is because individual codes in the program are used to determine payments, not as data points in a complex and rigorous statistical model. What are the implications for Relators Council looking at Medicare Advantage plans of this kind of quote?
So there has been a massive issue as it relates to unsupported diagnoses. You'll find this in the panel opinion as well. They report that audits done showed that as much as 10% of the money that's being paid out to Medicaid Advantage insurers, that's more than $16 billion in this audit, were paid according to unsupported diagnosis codes. So there's a lot of money floating around in this system. And I think for relators who are aware that their insurance employer or that their insurer has been systematically sending unsupported diagnosis codes over to CMS, that can be a really powerful claim. And the DC Circuit's rule sort of validates the underlying law that gives rise to that claim.
Let's talk about our second case. This is US XREL Prose versus Molina Healthcare of Illinois. This is another managed care decision, but this time out of the Seventh Circuit. And in this case, the relator alleges that the defendant managed care organizations promised to provide SNF services, skilled nursing services, to beneficiaries, but stop providing those services mid-contract and yet continue charging the government inflated capitation rates that assumed the provision of SNF services. That seems pretty straightforward, but in fact, it was a split decision here by the Seventh Circuit. What's going on here?
Yeah, so this is a case that I had the good fortune to represent the relator in this case. And the allegation is exactly as you described. A basket of services was offered to the government, including these skilled nursing facility services that included having a physician around and able to deal with sort of the primary care needs of the nursing home population. And then they stopped providing those services, but continued charging the government capitation rates that assumed the services were being provided. So it's basic overcharging, right? You offered a basket of services, you took something out of the basket, you charged them for the whole basket. And the basic fight in this case, the reason that it got up on appeal in the first place, is that the district court sort of thought, and this is a narrative that defendants like to push a lot, look, this is just a breach of contract case. This is not a False Claims Act case. There's a difference between breach of contract and fraud, and you're blowing this all out of proportion. And so the district court threw the case out at the pleading stage on that logic. And then on appeal, the Court of Appeal says, no, when you knowingly breach your contractual obligation to provide services, but charge full price, thereby submitting claims for payment, you've got everything you need for a False Claims Act violation there. It's not just a breach of contract. There's also this element of knowing conduct and signing up new patients and continuing to charge, even though you knew you weren't providing the services. And so the case is really a good one for exploring where the line is between breach of contract and false claims. And I think that's also where the line is between the majority and the dissent. The dissent really thinks like, look, maybe they didn't provide all the services they said they were going to provide, but I don't know if this really rises to the level of fraud or deception.
So the dissent says that Molina's strongest argument is that the government renewed the contract after learning that Molina could no longer provide the SNF services. What are the lessons of this case where that has occurred?
So in this case, I'm actually not sure the dissent has that point right, because the relator alleges that the contracts were renewed, but actually Molina concealed that it was not providing the SNF services at the time. So one of the claims is a fraudulent inducement claim based on the contract renewals. But let's take the premise as given and say that that's true, that sometimes the government renews a contract despite knowing of non-compliance. We all know that after Escobar, the government's payment of claims with actual knowledge of violations can be strong evidence that whatever requirement was violated wasn't material. But there's a good point to be made that when you're talking about something like this case, where there's a basket of services and the non-compliance is that some of them weren't being provided, that's a different kettle of fish from trying to figure out whether some regulatory requirement is material to payment decisions. When you're actually not giving the government what it paid for, I think the materiality argument for the relator is much, much stronger than if the regulation only has some attenuated relationship to the payment.
Let's talk about our last case. It's also out of the Seventh Circuit, Supervalu, and this is a decision in which the relators allege that the defendant knowingly filed false reports of its pharmacy's usual and customary drug prices when it sought reimbursement under Medicare and Medicaid. What is a pharmacy's usual and customary price, and why does it matter?
You know, when pharmacies seek reimbursement from the government for drug sales, they have to set the price. So it's now like famous that the government doesn't negotiate drug prices, right? Not with manufacturers or anybody else. Instead, they have a variety of mechanisms to make sure that they're not overpaying for drugs. And one of those is that the pharmacies are required to report what are called usual and customary drug prices, which are the prices that they would charge to cash customers coming in off the street. So if you went to a CVS, you had no insurance and you were going to pay for some prescription drug, how much would you really have to pay out of pocket? That's generally regarded as the usual and customary price. And you can understand why the government doesn't want to pay more than that, right? The government is a giant entity with lots of buying power, directing huge volume to the pharmacies. Normally, buying power and volume mean discounts. And so if Joe Schmo can walk in and pay $20 for a drug, the government doesn't really want to be paying $40 for the drug. The way that this winds up being a problem is that the term usual and customary hasn't been that clearly defined. And so what pharmacies have often done, and there are several different examples of this involving different pharmacies and different schemes, is they often have discount programs where they'll say to the customer, hey, if you come in, the normal cash price would be $20 for this drug. But if you can show us that another pharmacy is offering it for less, we'll match their price, no questions asked. Or you can join our discount loyalty club. It's free to join. And if you join it, then the cost is $5. And so the pharmacy is actually only charging less money to the customers in practice, but they still have a nominal retail price of the $20, which is what they report as their usual and customary price. And the upshot is that sometimes the government can wind up paying a lot more money than Joe Schmo for the same drug.
So this case turned on a reading of the Fair Credit Reporting Act. What does the Fair Credit Reporting Act have to do with intent under the False Claims Act?
If you ask me, almost nothing. But in the Fair Credit Reporting Act, there's a provision that says that anytime somebody takes an adverse action against a consumer on the basis of their credit score, they have to send a notice to that consumer. And the notice has to say, hey, part of the reason we're taking this adverse action against you is because you don't have a very good credit score. And there was a case in the Supreme Court called Safeco Insurance versus Burr. And in Safeco, what the Supreme Court said was, and there were damages available for violating that requirement I just described, but only if you acted willfully could you get the real damages. If the defendant acted willfully, could the plaintiff get the real damages. And so the Supreme Court said two things. First, it said the term willfully encompasses more than just intentional violations. It also encompasses reckless ones. And then second, when you're considering whether the defendant acted recklessly, you should ask whether the defendant had an objectively reasonable interpretation of the statute. And if it did, then it can't be said to have acted willfully unless it was warned away from that interpretation by authoritative guidance, like a circuit court decision or guidance from the government. And in that case, the Safeco case, the insurer was found not to have acted willfully because they had an objectively reasonable interpretation for why they weren't sending these notices to the consumers, and they hadn't been warned that their interpretation was wrong. The panel in the Seventh Circuit says, well, the False Claims Act applies to people who act knowingly, not willfully. Knowingly in the False Claims Act includes actual knowledge, reckless disregard, and deliberate indifference. We think those things are pretty similar to the Safeco standard. So we're going to say that if you had a reasonable interpretation of what usual and customary prices were, and nobody warned you away from it, then you're okay. You can't be said to have acted knowingly. And that was the holding of the divided panel in the Supervalu case.
So is this case potentially a big deal?
This case is quite a big deal. It tees up a circuit split about whether the Safeco standard applies, but also it does this remarkable damage to the False Claims Act. So I just want you to imagine with me the following hypothetical. You have a classic vaudeville villain. Like the guy sits there, he twists his mustache, he's black and white even, and he just plots how he's going to get money from the government. And he comes up with a scheme to submit false claims, and he believes he's submitting false claims, and actually he is submitting false claims. That guy can get off of liability under Safeco because if his lawyers can come up with some objectively reasonable interpretation of the law that he maybe could have complied with, his subjective intent is just totally irrelevant. And I think it's very, very hard to take that scenario and say that's the right answer under the False Claims Act. And it's going to be a big deal because there are tons of situations in which the legal requirements, especially in the healthcare space, have not been fully fleshed out. And if there's a rule that says that when they haven't been, it's really on the government to warn defendants away from certain interpretations and not defendants' obligations to figure out when they should be asking for public money and when they shouldn't, it's a green light to exploit every ambiguity and to scuttle cases that try to redress those. So I think it is a really, really big deal.
Tejinder, thank you. And thanks to each of you for joining us for this edition of The Rounds FCA News with Tejinder Singh. We look forward to seeing you next time.